Yesterday, your lordship directed me to.
Oh, yes, you have informed them.
Yes, I have served them a notice, my lord, of mentioning.
What is it? What is the urgency?
My lord, the urgency is this, my lord. What happened in this matter, my lord? The writ petition is pending. Interim order has been granted after the date of stay of the superannuation notice. Superannuation
Or
notice.
date of birth issue.
Date of birth issue, my lord.
Give it.
Now,
Next
he is every day, every alternative day, he is writing a letter.
Next week. Next week.
Well, kindly fix any date, my lord.
Come tomorrow.
Tomorrow, my lord, as your lordship knows.
No, we know. That's why we are.
My lord, if I will be agreeable to come
next week.
tomorrow.
Subject to the leave of.
Yes, you are coming tomorrow. Yes.
This is item number 41. Regulation, Madam Led. Many of us have already attained the age of retirement.
It's on the list already.
On the list, but if it is not taken today, kindly fixes the time, if possible.
Let's see. You mention on Monday if it is not taken.
Monday.
Yes.
Subject to.
I have just a case of the rejection of the opposite document from Apple. And so I have filed.
What do you want? Inclusion?
I have completed it. I have approved 29 got returned. That's not interesting. I want to.
क्या देखो? What is it? There is an order for listing. What is he saying not returned? From where it has not returned?
I have also shot the notice to the other side.
No, what do you mean not returned? From where it has to return?
Such a file is of 18 number 18. And this has been already disposed of. And I have appealed against the order of that.
What do you want?
I want to have listed.
There is, what is it? Miscellaneous MAT or what is it? So it include it in the next monthly list, yes. Huh?
Only listing. Content.
Yes, give.
It's
Oh, new filing, then you have to mention there. Don't mention here.
grateful, my lord.
Subject to the leave of the court.
You understand something, sir? You don't know what is going on. You are mentioning in the wrong court. It's a new matter you don't mention here. It is arising out of what? A service matter. Oh, then it will come here.
Yes. Subject to the leave of this restoration application.
What is it?
Restoration matter is dismissed for.
Yes, give it next week, any day.
But I am drawing your lordship's attention that today, my lord, I have got information from my learned friend, Mr. Pankaj Haldar. He left Calcutta for treatment. My lord, he will come back after 2 weeks, my lord. This matter will be taken up at number 3.
It has been called?
Yes, my lord. May be taken up after 2 weeks, my lord.
When it is called, you mention you are in a rush. You have to leave. Wait, yes.
Number 1.
I'm appearing for the applicant, my lord, in can number 2.
Number 2 is their application, your lordship. The wife, I am the husband, my lord. This is my review application is mine. But the
what is your application?
File this application for interim maintenance and the litigation cost. My lord, the order passed on 7th of October 2024. The Honorable Division Bench had passed the order setting aside the decree of divorce. Decree of divorce passed by the learned Additional District Judge, First Court, Barakpur. Thereafter, they have preferred the review, but no copy was served. When we have communicated the order to the department of he is a central government employee working in a gun shell factory. So when we have communicated the order, the office informed that the review filed by the husband. Then I have filed this application under section 36 of the Special Marriage Act for interim maintenance and the litigation cost. My lord, kindly come to the page 19 of my application. That is the interim order passed by the Honorable Division Bench during the course of hearing of the appeal. Second paragraph of page 19. It appears that the appellant is a housewife with no income by her own. The respondent is an employee of Kashipur Gun and Shell Factory, Government of India. The salary slip produced for the month of July 2022 would show that his total earning is rupees 79,180, and after statutory deduction it comes to 61,610. In a proceeding under section 125 of the Code of Criminal Procedure, the appellant is receiving rupees 7,000 per month, which is being regularly paid. Prior to dismissal of the suit, the matrimonial court granted alimony pendent light at the rate of 5,000 per month. The said amount was fixed when his gross earning was 62,000 approximately. Since there is an increment of the extent of rupees 18,000 over a period of time, the maintenance amount is determined to rupees 17,000 per month, which would cover rupees 7,000 to be paid in the proceeding under section 125 of the Code of Criminal Procedure. The appellant petitioner shall be entitled to alimony pendent light at the rate of rupees 17,000 per month from the date of filing of this application till the disposal of the appeal. The arrear amount shall be cleared by 28 October 2022. However, the maintenance for the month of October 2022 shall be paid by 7th of October 2022, and future payment towards maintenance shall be paid by 7th each succeeding month. Thereafter, till the disposal of the appeal, the wife received rupees 17,000 per month as alimony. And after the disposal, she is getting only 7,000 according to the order passed by the learned court.
So she is getting the maintenance at the moment.
7,000, only 7,000.
We have filed a review.
Yes, my lord. We have filed a review, my lord. In this application, your lordship, only my objection is, your lordship, that the affidavit of disclosure has not been done, my lord. If that can be done, my lord, then an interim, whatever maintenance that your lordship so pleases, that may be directed, your lordship. We have
What affidavit of disclosure?
my lord, subject to correction, your lordship, as per Rajneesh's judgment, your lordship, the disclosure
Yes.
is mandatory.
Yes, my lord. Affidavit of disclosures submitted by both the parties before the Honorable Division Bench at the time of hearing of the appeal.
That has to be part of this application as well, your lordship,
Yes.
because
It was submitted.
without
And
that,
my lord, I have a copy from his employer that now the salary is 1,04,799.
This is part of your affidavit.
This is not part of my
Place
affidavit.
it, give it to him.
I have been,
Yes, I have
the
given
disclosure
copy.
has not been handed over to
Okay.
me, your lordship.
What is this?
This is, my lord, only the employer's disclosure by virtue of an
So
RTA
what,
that they have
what else
obtained.
do you want her to place on?
The affidavit of disclosures of assets and liabilities, your lordship. That has to be part
Yes,
of this
it was
application.
submitted. It was on
This
kept on
application
record.
also, it has to
It
be
is
part of
already
it.
submitted.
Already submitted by both the parties at the time of hearing before the Honorable
in the
Division
appeal.
Bench, presided by Honorable Justice Showmanson. It was submitted.
That is
So
not on this application.
For a long
Really difficult.
time, the matter was heard by for a long time
No, no.
before this Honorable Court.
Whatever it is,
It was submitted.
if you
Considering all these relevant documents and the affidavit, the order was passed by your lordship.
no, but you are not satisfied with that order.
No, my lord, I am satisfied.
You want the same amount.
No.
Now they want amount of 40,000 rupees, your lordship.
Therefore, if you
Yes.
are not satisfied with that amount, you have to come out with something more than that
Yes,
or something up to date.
I have submitted.
This is not the way. You have to place it on record, whatever it is.
Yes, kindly give me some time. It will be submitted on affidavit.
You have filed which can for maintenance?
Can 2 in the review application 352 of 2024.
The learned advocate for the we have said 1 week extra. In the meantime, if reply is to be filed.
21st
21st.
এটা ওর সঙ্গে ছিল কারণ তো
I've got the petition. Sorry, my lord, my client is down with viral fever. He was supposed to file within 7 days. 7 days reply. So while kindly adjourn it for fortnight, he remained he appear come and perform this affidavit. Compassionate appointment about that matter.
Copy is served for filing a reply. The learned
কারণ সে
But Mr. Pankaj Haldar appearing in this matter for the appellant, my lord. He requested me over telephone that he left Calcutta for proper treatment so that 2 weeks time may be granted.
No, we had told the learned advocate yesterday that now we are not going to adjourn this matter. Every day new ground is being raised. We don't appreciate. Ask him to come. Who is on record?
But I am not in this matter.
Then why you have come? The clerk told you what happened yesterday.
Only requested me over telephone.
Did the clerk tell you what happened yesterday and the day before that?
I do not know, my.
So why you are here? You send him. The adjournment business unnecessary. Ask him to be here at the time of rising before recess. This is not the way.
10:04
None appears for either parties.
That we adjourn it for the day. In item number 5, we have a press case. The appeal was preferred challenging an interlocutory order passed in the contempt proceeding, Your Lordship. Subsequently, Your Lordship, the contempt proceeding has been dropped. Final order has been.
So infructuous. The learned advocate for the
This is my appeal, ma'am. May I file subsequent to the leave granted my earlier supplementary affidavit, ma'am, and may I hand up a copy? This essentially are the proceedings which are pending against the respondents. Well, this is with regard to that LOC. Admittedly, they have gone several times abroad. My only endeavor was that there is an apprehension of the bank that since the husband has also been granted the liberty to travel, both the children have a permanent visa and permanent liberty to stay in London, there is an apprehension that they might settle in London.
So therefore, the page 5, second paragraph,
Yes, I've
adequate, say, what more can a court do?
that is a reasonable apprehension, but
We can't allow a detention of sorts. We are informed by the
My lord, I am appearing of the respondent writ petitioner, my lord. On 3rd July, your lordship was pleased to direct to file affidavit in so far the application filed by me, my lord. It is a case where the Supreme Court has remanded the
yes.
matter.
So who has to file affidavit? They have to
Yes,
file.
yes, yes.
He has been ill all this week. We have been facing a mentioning.
My lord, government has changed, but they have taken the same stand. My lord, since 2024, your lordship kindly go through the my lord order sheet, one after another adjournment, my lord, on the behalf of the government. It is their appeal and they are taking that time.
It is surviving for you now.
Not my survival, my lord.
No, this appeal is now surviving for your
Yes,
benefit.
yes, yes. That's my
Not
lord,
for their benefit.
that's my lord, appreciate because
So let them
neither
file their affidavit. We'll consider. She is unwell. We have been informed
yes,
throughout
my
the
lord,
week.
that I am not standing in the way, but my lord,
Do it by Monday. By Monday week. You have more than a week. Yes. This on
on the week, and I will take
Limit.
Same issue, my lord. Let it be kept on the same date, my lord. My lord.
Which
It will be-
earlier
Yes, as 7. Let it be kept on the same date.
list on 27.
Petitioner respondents. Writ petitioner respondents. I am for the writ petitioner respondents.
My lord, I'm for the corporation.
Both sides are here.
My lord, the state is the appellant. I'm the.
27. Same day.
Same date. My lord.
Item 9. I beg to appear for the petitioner appellant.
You are not appearing yesterday.
First
Oh.
appeal.
Sorry. Yes.
The subject matter of the petition is that, my lord, by an
What is the order passed by the writ court dated 29/6/2012?
what happened, my lord, 2006, my lord. Even the order has been passed by the senior superintendent of post office, my lord. By an official instruction, my lord. Although the writ petitioner, my lord, I will be writ petitioner.
So relief has been granted you, then why you have filed the appeal?
My lord, what happened, my lord? I am telling you. My lord,
No, when the order of freezing of your account has been set aside, then why you have filed an appeal?
let the it has not set aside. Set aside, my lord. My lord, the writ petitioner said that
What is the date of order impugned in the appeal?
12/2/2013, my lord.
12/2.
12 February 2013. Let me the memorandum of appeal. Order was an official communication by the superintendent of post offices, my lord, by instructing the several post offices, my lord. Altogether 44, my lord, accounts as thought to have been rejected, my lord, you have been freed. My lord, we do not, the petitioners, after requiring several representations, my lord, only in 2008, having found that it has been seized. My lord, in 2012 only, the petitioners were given the official communication. Thereafter, my lord, the petition was filed. My lord, what happened, my lord? There may be, my lord. My lord,
Where is the impugned order? P1, annexure P1.
my lord, there is an injunction application. There is an injunction application also, my lord. I do not want to place, my lord. There is no.
Yes, there is an injunction application.
My lord, I am placing on
24/4/2006. Where is the order of 24? Just.
But at the relevant point of time, we have two issues, my lord. At the relevant point of time, the Honorable Court did not have the determination to determine the subject matter of the writ petition, my lord. The subject matter of the writ petition was of, my lord, group 9, my lord. My lord, at the relevant point of time, I have the copy of the determination that can have a look. Can you have a consideration? My lord, this is the determination on the relevant date when the writ petition was disposed of. My lord, on the same date, my lord, court should not have the determination as per the roster, my lord. This matter pertains to group 9, my lord, regarding the freezing of the postal bank account, my lord, not related to the service, my lord. There was no connection with relation to the service, my lord, of the writ petition. My lord, under the CCS rules, my lord, there was no prescription of punishment prescribed in the rules, my lord, for the purpose of freezing the bank account. There may be minor or major punishments, my lord, but the freezing of bank account was not prescribed in the rules, my lord. Even there may be a disciplinary proceedings, my lord. Under the rules, there is no prescription for that, my lord. My lord, my point is that, my lord, at the relevant time, the learned advocate had failed to make submission with regard to this issue, my lord. My lord, the concession or, my lord, the misunderstanding of the learned advocate cannot bind the client, my lord.
ESL division में
একটা লিস্ট দিয়ে আমি আমি রাখুন তিনটেই আছে আমার কাছে দেখে নিন আপনি
My lord, an order passed by a bench, my lord, not conferred with the determination, stand to be vitiated, my lord. I have few decisions, my lord, few citations with regard to that, my lord.
show us copy of the writ petition.
My lord. There is a type copy of the imprint order in the next page, my lord. The original was not legible properly. There was no whisper, no mentioning of the reason of freezing, my lord.
How many writ petitioners?
8, my lord. My lord, they are all retired, my lord, having age, who got superannuation, annuated.
Yes, how do you justify issuing such orders?
Union of India, Lord.
Yes, you have to respond. How do you justify issuing such orders?
Senior is feeling ill, that is, I am not equipped with the brief, my lord.
You are an employer. By one order, you have directed the various
44.
postmasters to freeze all the accounts of these employees. Under what provision you have directed for stoppage of the payment? Whether you can do this, whether you have the jurisdiction to pass such an order without giving them an opportunity, not even serving them copy of the order. That's the only issue. Did they file opposition in the writ proceeding?
No,
You file whatever you want to file, we'll dispose it of.
And have a date, my lord, on the next date I shall.
The opposition learned advocate for the
August. 28.
You file it within 3 weeks, you give him a copy.
My lord, in this matter, on behalf of the respondent.
But I'm praying for not this week, my lord, because
My lord, last time also they took time, my lord. Nobody appeared.
Last time you did not appear.
Yes, my lord.
last time I'm not taking time.
They didn't appear.
They did not appear. A separate list after 1 week.
Item 11.
My lord, I am appearing on behalf of the Life Insurance Corporation of India. As per the LIC's, the dues has already been paid. Only group insurance, your lordship, has already been directed to Oriental Insurance Company to review, and Oriental Insurance Company. We have already submitted the document, necessary document to the Oriental Insurance Company.
Payment made.
Till now, I do not know. We have submitted the document to the Oriental Insurance Company for the disbursement. Group insurance. For
My
group
lords, if I may, I am appearing for the Oriental Insurance Respondent number 3, my lord. My lord, as per the order directed on 14th of June, only one element is left to be adjudicated, and that's the, if I can read the paragraph 3, the only issue that now survives is the writ petitioner's claim for interest against the Life Insurance Corporation. Oriental Insurance has already agreed to process as per the formalities, but condoning the 19 months delay, your lordship. So that issue is already closed, your lordships.
That is paid. No, nothing has been paid. Is it paid already?
I am not aware, your lordship. Just now I came to know that they have already applied, so I'm not aware about that, your lordship.
But suppose you are the payee, how can you say you are not aware? Either you have paid or you have not paid.
May I ask my learned friend that when it was submitted, then I can take the instructions from them. But they, as per the affidavit, we had agreed that we will pay condoning the delay of 19 months, your lordship.
Quite some time back, about a month back. So therefore, we are asking you more than a month. Has the dues been paid? Who made the application? You or they made the application?
Because it is between the LIC
Yes,
and the Orient.
we remember. That's why we are asking.
Because we are not in a
submitted the
position.
necessary document.
When you submitted it?
Repudiation was only on the point of delay, which was turned down, and in fact, she asked me to get on some judgments also of the Supreme Court.
Now that issue is over.
In fact, that has given a go by.
That is
28 July.
Huh?
28 July.
Why you take so long?
The old matter, that's why
Therefore, it should become very old. An old matter should become very old. That is how you are trying to justify this sluggish attitude. Since 11 June, we are now at the end of July. And you say because it's old, we'll take our own time. You want us to record that? That this is the stand of the corporation, that because it's an old matter, they will take their own time in doing what?
for necessary document. Thereafter, we have.
Why so long? Throughout this proceeding, the stand of the LIC, we have not been appreciating at all. This is most least expected from you. This is least expected from you. When you know the circumstance in which the writ petitioner
I'm the writ petitioner.
is going through, you secure the life of
It's for
everybody,
cancel
and
petition.
this you are doing with your own employee. It's an old matter, so we will take our own time.
The old document has to be collected from the department.
What document, sir?
You
were saying that we are not being allowed, therefore it could not be done, as if everything was ready in your hands. And when they have agreed, then you are taking all the time in the world, 2 months just to send the application. How they will get? So they will press for interest till the date of payment. Mind you, we are not saying what we are going to do, what we will do, we don't know, but they will be pressing till the date of payment. And this is going in the record. This is the way you are procrastinating. Show some due diligence. After that date, 17th also, You sought an adjournment,
My personal complaint.
so we granted. But your client, that adjournment itself was sought 1 month, more than 1 month after they had agreed. You make the payment, make it swift. As it is, since when you are claiming interest, since which date?
The time he expired in 2023.
So,
And thereafter, the situations roll. And in fact, the Oriental stand is, since they were late, we are not going to pay, but somebody has to pay.
no, that is already,
That is another part of the story that will.
that is issue is not in the realm of any.
Just take it. LIC will pay. We will phone.
That issue is not in the realm of
Not in the
dispute,
scenario at present.
not in dispute, because we have already said that the claim will be against them. So
Great.
therefore, that
But
is.
there is a civil dispute, I have already ventilated before your lordship, and I.
So we will go through that,
Yes.
but that whatever the date has to be paid with till which date we will claim an interest. So you tell us which date you will make the payment, then we'll consider whether the circumstances
We have
warrant.
already submitted the document to the Oriental Insurance Company for disbursement.
Sir, if you had shown some diligence, there would be no scope for us to doubt or keep it pending. After 2 months, we are at the same position. Therefore, we want you to complete this payment process before we proceed further in the matter. She is a widow.
And also a cancer patient.
Till date, no payments have been made.
Your Lordship, may I request for one thing? If a
Yes.
copy can be served to me, then I can personally pursue and follow with the Oriental Insurance.
I have just received through my message, my lord.
So get a
I will
printout. We are the learned advocate
For-
for the
for-
Oriental Insurance submits that.
Give the copy.
Give it to him.
Yes. Biblio.
Grateful, Your Lordships.
Problem is reasonable. We don't want to push things, but you should. This is not expected.
The 28 is changed.
Changed 4 weeks because 1 week they will give, then they must get 3 weeks time to do whatever they want.
For the disbursement. তাহলে 28 আর থাকবে না। 1 তারিখ করুন। 1 তারিখ। First September. Right.
My lord, are you
Grateful, Your Lordships.
and my lord, item number 9, my lord, I have given the copy of the read petition, my lord, that I want to withdraw.
Copy of the writ petition is
My lord, I have to provide a copy to the respondent, my lord.
on record.
9, my lord.
9.
I'm grateful, my lord. Item 12.
None appears for the part.
paying 1 week adjournment, my lord. I have not, I prepared the affidavit in reply, but the appellant is some difficulties. He could not
As
come.
prayed by the learned advocate for the appellant, matter is adjourned 1 week.
Item 14.
Your Lordship, I am appearing on behalf of the appellants.
Lordship, learned ADP is appearing.
Let's see, what is it? Intra-court appeal.
Yes, Your Lordship, the interim order passed by the learned honorable single bench. Lordship, may I submit?
What happened on the next date after this?
Your Lordship, I have filed one supplementary affidavit, which is including few very relevant documents of the writ petition, and which suggests that after the Public Service Commission had published the question papers and the answer scripts, the complainants made complaint to the Public Service Commission for looking into the irregularities, and it had not enclosed any relevant documents at the
You are
time.
for whom?
I am submitting on behalf of few candidates, Your Lordship, who were not the writ petitioners before the Honorable Single Bench, but they are aggrieved by the non-publication of the results for a very long period of time, and they have performed very well, and these centers had not witnessed any irregularities, Your Lordship. And
So center-wise, it can be allowed, even though there are.
Your Lordship, if any report can be called from the CID, Your Lordship, this the question papers which
So some examinees will remain in the fringe because there was an irregularity, and other center examinees should be given the benefit.
Your Lordship, unless this entire the examination centers in
So
which
those who have suffered a wrong, they should be left at that, and others
Your
claim
Lordship,
should be processed.
the complaints which are the mainstay of the writ petition are suffering from infirmities. We had served them copies,
So
but
they are FIRs. How this court will look into it? There are so many FIRs, 60 FIRs.
But charge sheets have been filed.
Whatever it will, that will be done in the trial. Where's the question of
Your
this court
Lordship,
looking into those things?
One judgment of the Honorable Supreme Court.
Yes.
I had prayed.
No, to support what submission that we are asking.
Yes, Your Lordship. This supplement.
See, as it is, the fact not in dispute is that there are 60 FIRs. There is probably a large scale irregularity in conduct of the recruitment process. The single judge has stated. You say no, everything was already published by result. Is it possible to do so? And this judgment that you say it will support such a view.
Yes, Your Lordship, such a view because some irregularities of the identical natures were witnessed in this.
We are not going to go into the nature of irregularities. We will not even tread there. The larger issue only has to be seen.
If they are
We are not sitting in appeal over the proceeding in the criminal trial or whatever is going on.
Your Lordship, this is a nationwide examination was conducted,
Yes.
and it was stayed. Irregularities were detected in the process of examination, but later on, the Honorable Apex Court had set aside any possibility of staying the examination process, and it was regularized, Your Lordship, because there was no evidence of this witness WhatsApp messages and other irregularities were found and tainted.
That is not the stage yet. Here it is at the stage of FIR. There was FIRs.
Yes, Your Lordship. Here also FIR was there, Your Lordship.
So how it can be done? We don't know. We have not gone into the which judgment you are relying upon.
Yes. Vashika Yadav versus Union of India, 2nd August 2024. Agent. Was passed by Honorable Chief Justice, Your Lordship. May I submit the nature of allegations in my complaint, Your Lordship?
No, we are not going to look into that. Sorry.
Yes, yes. I will detail the judgment passed by the Honorable Apex Court. CBI was undertaking investigation in this recruitment process, Your Lordship. It has been mentioned in paragraph.
Madam, look at paragraph 5 of the judgment
13.
you are relying upon. Read paragraph 5 of the judgment that you are relying upon.
Paragraph 13.
No, paragraph 5.
Yes, Your Lordship. Part A leaked or illegally circulated amongst some students prior to the conduct of the exam at Hazaribagh in Jharkhand and in Patna. First information reports were registered in multiple states, including Bihar,
Madam,
Maharashtra.
paragraph
Gujarat.
5, the result therein was published by the NTA. In your case, there is no publication of result.
Your Lordship, some variations can be there, but my.
Not a some variation. The process had concluded. Here it has not concluded. This is not a trivial difference that can be overlooked.
They have not published the results, Your Lordship, but here.
Here it was published. You see paragraph 5 of that judgment. When the result was declared on such and such date, it emerged that compensatory or grace marks were awarded. So this is a much later process. You are relying on that judgment. So we were wondering how it can be. Then there was a direction for fresh examination.
No, fresh examination was not conducted in this examination, Your Lordship. Results were declared and no further examination or the examination process was not set aside.
Madam, they were claiming conduct of fresh examination before the Supreme Court in that case.
Yes, but
it is totally a different circumstance. We don't know how you are relying upon here.
Yes, Your Lordship.
There the process concluded, whatever had to be done, results published, they were claiming fresh examination.
But
in that context, the Apex Court has passed the order. Any other judgment you
yes,
show
Your
us?
Lordship, had this met with the same fate, that result had been circulated, we would have asked for either for segregating.
That's not the issue. The issue is how this judgment applies to your prayer. You are saying there is a tainted recruitment process where there are 60 FIRs. Leave those FIRs and publish my result. And for that, you rely on this judgment.
Your Lordship,
we ask you.
CID was directed to submit a report, Your Lordship, on the next.
I'm not going to go into that. That is pending before the single judge.
Your Lordship, there
is just an order which you have challenged today. So where is the question of us passing an order to publish the final result?
Your
You
Lordship,
appear before the single judge. Who is stopping you?
We had appeared, Your Lordship. I had submitted one application before the Honorable Court in
Before this order?
2025.
Before this order?
Yes, Your Lordship, in 2025 May.
Yes.
But that application has not been heard. That writ petition itself is not heard, and the writ petitioners are not interested for hearing of their application
We don't know whether you can say so on their behalf.
because they never make.
We don't know whether you can say so on their behalf.
We are not getting any relief, Your Lordship.
You cannot. Obviously, you cannot.
At
A
least
recruitment
this,
process where there are 60 FIRs being investigated, you want the fruits of that result, of that recruitment process.
at least it may be concluded, it may be scrapped, new recruitment process may be initiated, Your Lordship.
You seek that
Retest
relief.
may be conducted.
You seek that relief in an appropriate
Retest-
proceeding. You can seek that relief. Whether you can get it or not, we don't know.
Any
We will not access, we will not consider the entire writ petition here. Because there is one order before us. That is all.
Your Lordship, there are two orders, Your Lordship.
Yes.
One order is
Maybe two
24
orders. We'll still not consider the entire writ petition.
Your Lordship, direction may be given to the Honorable single bench so that this matter can be.
When you have
discussed and
mentioned?
I have mentioned on 14th of April last. I had mentioned on numerous occasions, Your Lordship. The last 1 year I had been mentioning.
Which is the other order? You have shown one order.
Yes, Your Lordship. Second order is at page number 72, Your Lordship, of my Can 2.
72.
Yes, Your Lordship.
Which can?
Can 2 of MAT 751. Yes, sir. It is the order dated 24/5/2020.
Subsequent to that order. Which is the later order? 72.
Can 2, Your Lordship. This may be Can 1 or supplementary. This may be the supplementary affidavit, Your Lordship.
It is only 52 pages.
একটু দেখিয়ে দেবেন Can 2.
72 is in supplementary.
14/7 Can.
72 also there is no such order. Supplementary also there is no.
No, it is in Can 2, Your Lordship. Can 2.
Can
Page 72.
no page of 72.
No page of 72.
There is no such page. There is page 72 in Can 2.
In page 15, Your Lordship. There may be some mistakes. Page 15, Your Lordship. Dated 24 May 2024.
This is the other order. Where is the other order? You said there are two orders.
Yes, 23. Previous one is the 23rd of April 2024. In the same copy. Some differences may be there in the.
That's not supposed to be.
Yes,
It's
Your
not
Lordship.
supposed to be like this.
Yes, Your Lordship. I
Yeah.
apologize, Your Lordship. Can 1, both the orders are there in page 12 and page 15. 12 is 12.
Where is the direction in which paragraph?
Paragraph 7, Your Lordship, of the order dated 24th May 2024. Later further company.
I'm asking you about this judgment that you are relying upon.
Oh.
Where is the direction to publish the result?
Your Lordship, it was referred in the last part. Um, Paragraph 109, Your Lordship, at page 32. The principal issue, may I read out, Your Lordship? Whether the principal issue which the court was concerned with in this case is whether the sanctity of the NEET was compromised this year and whether the process should be scrapped and a fresh test should be conveyed. Having answered the question in the above terms.
Above term. So where is that?
Yes,
That's
yes.
what we are
This
asking
term,
you.
this term is at para 8. Part A. This is at page 2, para 5, Your Lordship. Part A, leaked or illegally circulated amongst some students prior to the conduct of the exam at Hazaribagh in Jharkhand and Patna. First information reports 3 were registered in multiple states, including so and so. The addition.
The court has answered the question.
Yes.
You reading that. Your submission you are supporting with this judgment. So you show us where the court said. And in what circumstances the court said that you publish the result, even though there is.
Paragraph 8, 7.
Those are facts. That is not where the answer of the court is.
Court made certain, paragraph 11, Your Lordship, of page 4. The court also made certain observations on the competing considerations in a case such as the present one. In a situation where the breach in the sanctity of an examination affects the entirety of the process and it is not possible.
Madam, that is the law being stated. We are asking you where is the direction that you are seeking by us.
Lordship, a specific direction is there.
It is a settled law.
Yes.
Where there is a systemic irregularity or illegality, the entire process has to be scrapped. Where it is possible to segregate, it can be. You are saying that in this case, the apex court has directed that despite there being so many leaks and FIRs, you publish the results. So in what circumstance that we are trying to see? Where is that direction?
Yes, Your Lordship. In different parts, it has been addressed. Part
You
A.
have to tell us.
Yes, yes. Okay.
We have gone through the judgment.
Yes, Your Lordship.
Go through it. We are adjourning it for the day. Come on Monday. Not today. List tomorrow with a note not today.
Lordship, it is here, Your Lordship.
Call the next case. Not today.
15. results cannot be fastly certificated.
My lord, I am for the appellant in this matter. My lord, during the previous occasion, my lord asked to file this supplementary. My lord passed the direction to file the supplementary. Upon the direction of my lord, I am pressing the supplementary because the review medical report was not legible. So I have tried to type it.
Original copy of the report.
I have tried to type that, my lord, whatever is there, I have tried to type.
Made out your case if you could not read the document.
I could read with the lens, my lord, and then I got it typed, my lord. The main points I could bring before your lordship. Wait.
You have given a copy. Without giving a copy,
I said to my learned friend, but perhaps his senior will appear. May I read, my lord? Just
this is the RME or DME? This is RME.
this is RME, my lord. Review medical examination. May I read, my lord, the paragraph 2, the typed copy, which is at page number 4, my lord. Brief review medical examination findings thereof. As per the opinion of the psychologist, presence of emotional disturbance, difficulty in coping up with situational stress, multiple parallel scar marks, cuts 8 to 10, present over the left forearm, self-inflicted, admitted by the candidate herself, small scar, cut injury over the chin.
RME is signed by you.
RME, my lord will kindly appreciate that during such type of medical examination, there is a huge crowd. And this, there is a standard format where what I basis before your lordship will kindly appreciate that during this RME date. This 8/12, no
8/12.
8/12/2025.
2020.
Only my respectful submission before my lord is I am relying upon two things: whether these scar marks were self-inflicted or not. There is a standard format. What I am challenging is also their process. If these scar marks are self-inflicted, I have never admitted.
You have signed, that's why.
And there is a standard format. My lord will kindly appreciate there is a huge crowd during the time of the recruitment. Whatever.
Overlook.
No, it is
Then tomorrow
initially.
the candidate will sign and come here and say that I was in a rush.
My lord, it is not like this. My lord, when I was asked.
In a process where there is so much at stake, a job for you. So we don't expect that you will be so casual that because it is a crowd you will sign anything.
No, my lord will kindly appreciate
Unexpected normal human conduct.
my lord, my respect,
Take note of such.
my respectful submission before my lord is that during such processes, they are just the 10+2 pass students. They do not know much about the legal complexity of signing the documents, and during such crowds,
There is a written exam also.
there is a written exam. I have passed all the exam, my lord. I have passed all the exam except the review and
consequence of signing and signing.
no, I'm not.
Kind of submission you are.
I'm.
We thought you will come with something better. This is the only plea you have, then you are considering.
My lord,
So you
my,
said that this cannot be binding on you, it was done in a rush, you were not knowing the consequence. We'll consider that right now.
my lord,
Anything else?
my lord, I am also relying upon the statute. Mental Health Care Act 2017. My lord will kindly come to page number fourth page, section 3 and section 4. May I read, my lord?
No, let us go. Just let us go. You just given one page.
My lord, the relevant page I have placed.
It's not the way of looking at a statute. Not given the entire statute. Provision cannot be considered in isolation.
My lord, section 4.
We will not consider that. We will not.
My lord may fix the date, I will come with the statute.
The entire statute.
My lord, may fix it suitable.
Resistance.
For the respondent bank. Mr. Bishop Bhattacharya is appearing on behalf of the appellant. He is out of station. He is kindly praying for not this week.
Tomorrow with not today.
Can it be next week? He is not there. He's out of station.
Tomorrow with not today means what, sir?
Oh, sorry. For warning.
No, he's seeking in the next week. It will come in the next week on Monday. Item 17 and 18.
Have filed an application, my lord, which has not been served yet. It can be served and we can come back, my lord.
Both of you are for the same?
No, my lord, I'm for the petitioner, my lord, in
We have
17.
prayed for addition of parties, my lord.
So, opposition is already served. Reply not filed. Have you filed a reply? What do you want? What you are here for?
My lord, I'm praying for not this week, my lord. From item number 17 and 18. I am for the 19. And my lord for 20 to 22.
17, 18?
And 20 to 22, my lord. For 19.
Why you are leaving 19?
My lord, they are for the petitioner.
So 17 to 22, all have to be adjourned.
I am served with the affidavit in reply, your lordship.
They have served your reply. So why you have not filed it? Have you filed the reply?
My lord, I'm not currently aware of that, my lord.
As prayed by advocate for the petitioner, list after one.
कॉपी दो
10 of 24 दे देंगे आपको
लड़का कॉपी दो
दिए दो ठीक है सर
Your Lordship, I am for the petition. I am praying for not today. Your Lordship, my senior was ready to conduct the matter, but unfortunately in the morning, her mother is hospitalized. So I request you to kindly take the matter next week.
In this matter, I'm led by Mr. Ronjada. I'm praying if this matter could be taken up the week after, the next week he will not be available and he's leading me in this matter. Your
I jointly prayed list on Tuesday week. Tuesday.
Next Tuesday, 44. एक week run होता है.
125.
I'm for the credit.
You are for the respondent. In 25, none appears for the writ petitioner. List after a week.
In 24 and after. Thank you. Yes.
126.
My lord, I am appearing on behalf of the petitioner. My lord, there's a change brief. My lord, I've got the brief only day before yesterday. My lord, I have not gone through in a proper manner. My lord, I'm playing my lord 1 week accommodation. My lord.
Your Lordship, I am for the added respondent 6 to 21. Your Lordship, I was.
Any pleadings are to be exchanged? No.
Yes, Your Lordship. Yes, Your Lordship.
Complete.
No, Your Lordship. An affidavit on behalf of the added respondents need to be submitted with Your Lordship. I was only praying if Your Lordship kindly gives us 1 day's accommodation, we can come up with the affidavit. It is ready, Your Lordship.
So he's seeking adjournment. You do it in the meantime. That's why we are asking.
It's ready. It's ready, Your Lordship. Only thing needs to be done is submit it before Your Lordship.
You are added respondents in the tribunal or here?
Here.
Yeah.
How? Why?
Your Lordship, they were added because they had got the job and the service.
Yes, got
They are
that.
successful
Yes,
candidate.
You are filing an opposition.
Yes, Your Lordship.
I've not got it. So kindly supply me.
The learned advocate. Recorded, you do it right.
Lordship. We'll serve it in the meantime.
Yes.
Yes, matter, my lord. She was dismissed for default, man. That's previous matter. I think plan is trend is.
We should have.
Oh,
Yes.
should have.
Yes.
127.
Take it.
Charles.
None of you. Dr. Samar.
None appears on behalf of the parties.
And 28.
Is for default. Last date, 12/6/22. GD.
And 29.
Lord, in item number 29, my lord, I am for the appellant, my lord, that we have been instructed that the learned AGP has not come because of her illness, my lord. My lord, kindly takes it up on the next week, my lord.
On grounds of illness of on ground. Both of you want time.
And 30.
My lord, I am appearing for the petitioner.
The reason order of 11/10/23, where is it?
No, there is, but they have not passed any reason order. Only thing is that they have simply made the replica of the decision of the December proceedings. No, no. Attend na. So number 3, it isn't what a passport.
This hearing was according to you pursuant to which order?
This is the order, but this is against the order of the learned tribunal.
This hearing on 11/10/23, you were given a hearing. This was pursuant to which order? Passed by which forum? Tribunal, High Court? Who directed for this hearing?
Administrative, WBAT, West Bengal.
That order.
You know that page number 101.
No, that's not the order. Where is the order in WPST directing for this hearing?
Directing for the 95. You know, page 95.
এক নয় না চেঞ্জ করেছে and where is your representation of 12/7/23
Milord, as page 72.
yes yes
Milord, this is a service matter. Virtually, the disciplinary proceedings were drawn. And that disciplinary proceedings.
under which provision
That is the provision is the West Bengal classification and control.
that will apply to contractual employee
I am a contractual employee.
that applies to a contractual employee
Yes, Milord, because
under which provision show WBSR that it applies to contractual employees read which provision says
Milord, I have not brought my.
we have got it we are giving you please show us enlighten us WBSR giving
One each other. Classification order approves to name or that. তখন অ্যাপ্লিকেশনটা তো কত দিয়ে বুঝতে পারবে নেই আর একটু ওই ওয়েস্ট বেঙ্গল ক্লাসিফিকেশন এন্ড কন্ট্রোল অ্যাপ্লিকেশনটা পাওয়া যাবে এর মধ্যেটা নেই
it does not apply to contractual employees what are you submitting you cannot find any provision like that
My lord,
you will submit anything
no, my lord, there is a specific provision that
there is no provision it applies to government servants only
Lord, the problem is there.
All right, so that is your submission. What else is your submission? Tell us. No proceeding was conducted. What else?
The fact is that they are guided by the memo number 908F of the Government of West Bengal.
Very well.
There is no specific provision that as to how to conduct the proceedings.
Very well.
But they have conducted the proceedings.
No conduct. There is no conduct of proceeding.
Departmental proceedings.
Where is the charge memo? Show us.
That is my point of law, my lord.
So you can't say both. There is no charge memo and there is a proceeding. There can be no proceeding without charge memo.
Page 38.
Page 38, my lord.
Yes.
38.
Page,
From page 37. This is the order.
page 38.
Yes.
Point number 11 হবে দেখি ছাড়ো
কিন্তু এখানে আছে contextual order.
Hmm.
Yeah, so let's-
My lord, in the order itself, at page number
38.
38 of my petition, and read with page number 39, during the period of engagement, the service of a casual or daily rated contractual worker will be terminated because of involvement in criminal proceedings. Here, they can take the action. My point is that criminal proceedings has been quashed, had been set aside. Naturally, I am free, but therefore I am entitled for the installment in the service.
And back wages also.
Sir?
And back wages also. That you have stated, that put me back and give me back wages from December 2018. That is your prayer.
Right.
That's all. Which provision you are relying upon? Which judgment you are?
And also the administrative tribunal says that daily rated employees will not be guided. But if I am not the daily rated, but I am monthly rated casual, and in that case, I am entitled to be guided by that rule. But whatever it may be, my humble submission is this: that I was sacked on the basis, totally depending upon the focus that I am involved in criminal case. But I was made victim of the circumstances, and my learned CJM was pleased to acquit me of. And unfortunately, this has not been carried out. That is my humble prayer.
Yes, that's all.
38, can you?
I heard the learned advocate for the Item 31 and 32.
Lordship, in this matter, on behalf of landed HB, I am praying not this week. Kindly fix the matter. Hey,
Tomorrow.
Tomorrow we have another matter fixed at
Lordship, Monday.
all day. No, I do not know, but Mr. Mujumdar is not senior advocate is my other side. He said he will continue. I appear for the High Court administration in that matter, so I have to. Otherwise, that is why your Lordship were kind enough to fix my matter on 6th of this month. I am seeking only one indulgence, subject to what my esteemed friend and my friend. 20 who petition. 32 petition and 31 he is. Both are same.
Both are for petition.
Yes, both are same.
You are in the same boat.
Same. Now, 28 February, my Lord Justice Tandon and my Lord Justice Bishar, 2025. No, Justice. This was hard. The argument concluded, it was kept for records. And 3rd week of March, judgment was 2025. But it was my bad luck. The judgment could not be delivered. Now, dismissal took place 2022. She is an associate professor, the relentless injury and humiliation is continuing. Whether I am entitled on this special conspectus.
Why two writ petitions?
Two separate petitioners, stigmatic termination from service without there being any proceeding ever initiated. Now, in the opposition, they say that, you are a contractual employee, so there was no necessity. But they admit this was stigmatic.
And 5-judge bench, that was relied upon possibly. Dictation was also given. Now, and we were inspired, for the about the outcome. Be that as it may, the climate is changed, Today, no, because we have to address your Lordship afresh. Now, the only whether in a special circumstances, whether I can pursue your Lordship to take up the matter on 5th of this month, within 5 matters, so that, whatever may be the lengthy, even if, I lose, but even if it is eventually, whatever may be the outcome, I will follow, Bhagavad Gita.
Why on 5th? What is the magic in 5th? What is the magic in the date 5th?
5.
Yes.
Astrology.
Best of luck, 5th.
I always enjoy death at the hands of your Lordship because at least impartial justice.
4th partial justice.
No, 4th I will not be here. That is why.
Expected from us.
Time.
That is the least expected from us.
Yes. Least expected. I know, because your Lordships, I am of the opinion, although, it was a joke, that why do you always think that when a question comes from the bench, you take it as an adversary? That is, I said it is my incompetence. If possible.
As played by the parties. 5th, we have any matters?
The parties.
Yeah.
No, not parties. She said, AGP is in. That is why.
Next week
she will come.
Yes. Kindly record that that on a car.
So 5th, we are checking whether we have any 1 p.m. matter is there. How long you will take?
1 hour.
1 hour.
Half an hour.
Half an hour would be.
If you have a good case, you should not take more than 15 minutes.
Yes.
If you have a bad case, you can take days.
No, your Lordship, puts always, certain difficult question, and I always, take adjournment and fly.
10 minutes should suffice.
So 5th, we'll have it at 2. We have one more matter at
10:30.
No.
12:30. 12.
2 after the first 2 matter.
Deeply.
As played by learned advocate for the.
AGP is indisposed. I said that you kindly inform the bench that on account of her illness, she is absent from the court. So it is recorded that I have asked for adjournment.
But then she said, I have not paid.
You wanted to do the
and then he's standing behind you. Then he said, then you may record that I have.
No, that is that is why I always that is the cause of my suffering. My junior statement, it is, I bound by that, I take responsibility.
Yes.
Yes, only, yes, and I cannot fly,
So what is the big problem? I've said I want to create this consultancy system. You have not said that, sir.
Nowadays, everything is mirrored.
That's why whatever we say, everybody knows what's going on.
I leave it to you. I take my
Item 33.
33, my lord. Same prayer, my lord. Next Monday.
Appearing on behalf of the applicant in this matter.
Same order on grounds of illness.
June is the order recalling.
You've got it, 16 June. Yes.
Sorry. Data remote is equal to 0. State the order. 6th February, it was 16th June, it was admitted. After subsequent order, it was.
Admissions.
We are informed.
$7, 36 to 39, my lord, all are also, my lord,
Same.
group 7 matter. My lord, not issue is different, but my lord, those are also group 7 matter.
No, is it admitted or is it prior to admission?
What's that? 36 to 39.
Anything survives.
My lord, I had an instruction from my client way back. My lord, they said that there's no more subsisting, challenge no more subsisting. Because the impugned circular has been withdrawn by the railway.
That's why we are just looking that scanning has stopped.
Scanning has stopped. Probably my learned friend.
Yes, scanning has stopped. Not only that, and my lord, the period of that agreement, that was also.
But
What
we
to
have
do?
had
We have
the
issued.
circular, the scanning charges which were against the
We don't
policy.
have the committee. And my lord, I think my lord, my learned friends also agreed, my lord, if your lordship is pass the appropriate order.
Your agreement will have
No objection, my lord.
your agreement will confer jurisdiction on us.
No, my lord, we were challenging this scanning.
We are on determination only.
Oh, determination releases this.
Yes.
Releases.
Whatever has to be done.
Yes.
If it is brought to our notice, if unknowingly we had passed the order, then maybe. The matter relates to a
আমি আছি আর 35ও আছে, আমি 35 থেকে 39 সবেতেই আছি, আর এরা আছে 36 থেকে 39, আর একজন ওই যে আগে ছিল।
এখানে আমি অ্যাপেলেন্ট
40 days. Oh, 40 is. 40.
Lordship, in item number 40, I am for one of the respondents led by Mr. Shumo Mojumdar. Lordship, I seek for an adjournment for a day.
let's see who's for the applicant. Appears. None appears for. You are for Coal India.
Lordship.
Area 41.
None appears for the
My lord, I'm item number 41, my lord.
Yes,
I'm
41.
praying for short parcel, my lord. My lord, my senior is arguing courtroom number 8, my lord.
West Bengal administrative. Correctly. वही it is ये ना. Depth of river is wrong. Yes, it should be ST. Right?
Initially filed before the Honorable Single Bench. Now, the Honorable Single Bench was pleased to observe that since it arises from a application before the West Bengal Administrative Tribunal, it should be placed before the Division Bench. Accordingly, it was placed before the Honorable Chief Justice, and thereafter it was placed before the regular bench having this determination.
Is it not proper to correct the nomenclature of the case?
It should be. Should be.
So correct it. How the new number will be placed?
A fresh number will have to be generated.
Generated by the. So it is before. It has to be taken up by this court only.
Lordship.
We are informed that. Nomenclature has to be modified accordingly as WPS.
কোর্ট অফিসারের কাছ থেকে নাম্বারটা নিয়ে যাবে, নোটিশ দিবে, স্টেট ছাড়া এখানে মামলা করতে পারবে না।
Item 42.
And for the state lordship in 42.
None appears for the writ petitioner.
Item 43.
Lordship, Mr. Siddhartha Banerjee is appearing in this matter and he's on his legs. I'm requesting for a passover.
Not today.
Great.
Item 44 and 45.
I am for the appellant in 40.
I am for the Union of India, my lord, I laid by
Now,
landed
India
ESG, lord.
is the appellant in 45. Well, let me place my case first. Your lordship will find, sorry, my lord. I'm sorry, my lord, brief has not been ended, my lord, sorry, my lord. Number 5. Number 5, sir.
And I laid by landed ESG, my lord.
Led by?
Learned ASG, my lord, additional solicitor.
He will come?
Is coming.
So let me start, it will take some time. So after recess then.
Pick it up after this. All right, ask him to come. We'll take it up after recess.
After, lordship. God bless.
What's your name, bolo?
2 p.m.
PMLA 46.
Renewing my privilege to appear and address. This is that baseless allegations. Lordship may recall.
Call very soon.
Madam, absolutely, madam. But we have concluded our submissions, madam. I've led by Mr. Mujumdar, but they are about to give the reply. That was what your Lordship has recorded last.
He recorded the submission on the line.
But on the, in addition, my lord, if my lords command anything, any further my lord, query or something to my lord, refresh my memory and to assist your lordship, please call me, my lord.
My lord, there are get the file in the hand and how it starts coming.
Lordship. It happens.
My lord, there are 3 points.
Court trust issue. Court Calcutta. State clerk.
Yes,
State clerk.
Yes, clerk and my lord, disciplinary court red-handed. 3 points may not disturb the court's conscience. First, my lord, that the disciplinary authority, the order passed by the disciplinary authority imposing punishment, whether he is required to give reasons, and if at all, whether the order itself demonstrate any reason.
If it is in concurrence with the inquiry.
Yes, inquiry report. Now I have one judgment, my lord, the and whereas, it is a recital of fact, and it is not unknown to the honorable court at any point of time that when court narrates the facts as a part of a recital and then comes to a decision, then the Supreme Court said, that is my understanding, that any elaborate reasons, my lord, if I concur with the facts arrived at the inquiry, I am not required. The honorable single judge also, judgment are there.
If we remember, substantially there were 2 issues. One is acquittal in the criminal trial.
Yes, criminal trial. Let us best minute kindly go through your lordship's order. Let us eradicate all conflict between ears and eyes. Order dilan, acha dekhchen. Dekhi order de. দাঁড়িয়ে দিস কেন? তোকে আমাকে বসতে
বসতে বলে হবে।
Yes.
Yes. Now, my lord, this is my lord, the judgment reported volume 3 SCC, page 806. I repeat, for 2021, volume 3, Judge Sahib ke din na. Sorry, it office copy. Page 806, paragraph, just bahate dichi, sorry.
Copy debe?
Na, copy debo na, reported judgment. দিচ্ছি আমি দিয়ে পড়ে নিয়ে দিচ্ছি হ্যাঁ
Since according to you, I committed a wrong, so you would also commit a wrong.
Now, my lord, paragraph 11, paragraph 11, we start. We are of the view that the judgment is put in such a sense is not helpful to the case. Further, it is well settled that if the disciplinary authority accept the findings recorded by the officer and passes on detailed reasons are required to be recorded in the order imposing punishment. The punishment is imposed based on findings recorded in the inquiry officer report. As such, further elaborate reasons are required to be given by the disciplinary authority. As the departmental appeal was considered by the board of such and such, the board's decision is communicated such and such. So when there is a concurrence, my lord, I am not required. Here, my lord, and whereas, my lord, and rules also say, my lord, honorable single judge has also, my lord, relied on this. Now, my lord, the other fact which disturbed my lord's conscience, that the same set of, my lord, evidence and the acquittal, my lord, what is, my lord, the ramification of such acquittal in this disciplinary proceeding? 2018, the disciplinary proceedings order, and 2021, the acquittal. Now, my lord, how do I look into this, and what is the ramification on law? Copy আছে দিচ্ছি. I will give them a copy. This is the state of Madhya Pradesh versus Rajkumar Yadav. Honorable Supreme Court, this is report. Where is the article? Judgeship ke din.
Unreported.
Yes. Reportable from the website.
Now every judgment is reported. There is a neutral citation at the top left corner. So you don't say it is unreported. Not required to give you any copy.
Oh, then give it.
Already handed over.
Yes.
পড়ে দিয়ে দিচ্ছি। আচ্ছা দাঁড়া। Now, this is now, my lord, in my understanding, humble understanding,
This is considering GM tank and all these judgments.
yes. No, my lord, in this case, my lord, I confine my submission in response to Mr. Muzumdar, my learned esteemed senior friend's contention, that once it is done on the same set of evidence, the result is, my lord, the automatic exoneration from the disciplinary proceedings. I cannot look into other things. I said, my lord, the High Court, while exonerating, acquitted, my lord, the petitioner from the CBI court, then, my lord, for want of evidence, as well as, my lord, inability of then the part of the prosecution, my lord, to my lord, put certain questions to a vital witness. Apart from, my lord, baseless the observation, then what is this? My lord, kindly comes to, my lord, paragraph 3.3. The statement of the respondent, may I read for my lords? The statement of the respondent was that though the petitioner was acquitted in the case by the trial court, it was an acquittal by giving benefit of doubt. It was pointed out that the respondent was tracked for the serious offences in the nature of moral turpitude and was acquitted on technical ground. Therefore, he was not liable to be considered for the post of constable stated paragraph 53 C of the MP police regulation, such and such was not fit for stop police constable who was which is acquitted was a technical ground. But dismissing the petition, of the respondent, the simple judge took note of paragraph 53 of such and such regulation. He further took the view of the acquittal of the respondent in the case were not even clear acquittal. Fix of doubt. Service in the police department. According to the commission, the acquittal was honorable as per the 1992 of the judgment that it was acquittal, not with a clean acquittal. However, such and such, and the assisting advocates, such and such, with such and such. In the judgment of the commission, which the High Court has taken view, observed in 1992 of the judgment of the trial court, the respondent was honorably acquitted. Though it may be true that the trial court discussed the evidence before the recording, there is no good saying that what the court held was that the charge against the four accused such and such hearing reasonable doubt. The moving paragraph of 19 is extracted except such and such in the conspiracy has been is doubtful. Therefore, the other four accused are entitled to get the benefit of doubt. The charge against such and such thing are not beyond reasonable doubt. In the same way, the following is recorded at least such and such beyond reasonable doubt. And girl from guardianship kidnapping such and such section such and such the other is entitled to be acquitted on other charges. Concept of acquitted often becomes hazy. The court several occasions observed the expression of acquitted Civil 73 of Code 1816. These phrases are coined in the judicial pronouncement. When the court comes to a definitive conclusion in trial, evidence that the accused had not committed any offense he was charged,
This would stand in sharp contrast against allowing that because of some lacking prosecution case or the legal evidence or such and such, account of evidence is not convicted. If such eventualities are taken, the criminal jurisprudence is up to only that the offense has to be reasonable doubt. A simple example of distinction between other than relevant. In the case, say a person is charged for penalty misappropriation of money after trying comes to the person is not committed misappropriation, has not pocketed money, it amounts to a clean sheet with respect to the offense. It is supposed of the fact that misappropriation was not done. However, if the charge of does not prosecution case or weak evidence, it is not possible to record following about the commission of offense, which we find in such circumstances cannot be said to be honorable. The equity of found benefit of doubt is equity of best and technical ground. Is a technical consideration applied. The equity for the respondent was governed by such criteria. In such and such, this court should consider the question whether the candidature of the respondent to a development of their involvement case by mentioning such criteria, such and such, post of such and such, provision is selected subject to the verification of the antecedent or subsequently discharge. Cancel the screening committee of the Delhi police on the ground that they were not found suitable to the post of constable. Instead observe that the screening committee was within its right to cancel the candidature of the candidate, even the candidate was acquitted from criminal charge. But taking into account the nature of acquittal, and observe the persons involved in grave case and not acquitted could be properly kept out of police force if they acquitted or discharged. Stated this court does. If it is any experience officer of the screening committee who will be able judge the other acquitted or discharge candidate is likely to revert to similar activities in future with more strength and vigor in particular post in police force. I skip over. It was emphasized that satisfactory character antecedent has to be insisted for the person wishes to join the disciplinary force. Skip over. Because of intellectual verification, page for paragraph formula. The character and antecedent judge the suitability of the person to the post not emphasized. In versus Union of India, it was observed that it is one criteria which is necessary to be fulfilled before appointment is made, and the government should not have antecedent of such nature which may judge him unsuitable for the post. Then next, the law 7. The law is also well settled. Proceeding acquittal in criminal case, and the examination the criminal case would not entitle and would have to be reinstated as a necessary secretary to the acquittal. In of Reserve Bank of India, such and such, this court held that when an High Court acquitted the respondent employee by giving him a benefit of doubt, the bank rightly refused to reinstate him in service on the ground it was not honorable acquittal. The criminal antecedents of an employee and the nature of the acquittal is considered to apply employee even when entitled to pay allowance for the period concerned to the employee for treating the period of suspension of duty. In stated the respondent was charged in respect of offence of such and such, which were the offences in nature of great moral turpitude. Every moral turpitude has its own counts and begin to become either abhorrent or unacceptable conduct, and was also a protection of offence under the law. In given case, moral turpitude would result into legal guilt. It may be for a variety of reasons. Still, however, it remains a conduct against decency, morality, and norms practiced in a civil society, involving a serious discount and disability for such person in the given situation and in the given context. In service law jurisprudence, the involvement of a person in an offense or in conduct amounting to moral turpitude without anything else may become relevant consideration to judges' fitness to the post and to assess shows one such person into the employment. The necessary conclusion from parameters and principles summarized is that whether it is a question of recruiting a person into the service, still employee from service benefit is criminal antecedent in activity. The moral turpitude, the restriction of criminal case, as well as nature of his acquittal of criminal case are all genuine consideration to employee applied. The employer put the committee, but this is not arbitrary. The idea of discretion vested the discretion committee, each figure is wide enough to exclude the candidate or reject him of giving appointment in a given case where the facts are stark, no involvement of person offense or the act of government become sufficient enough to apply it as deliberating factor for such candidate to be offered employment and to support some candidate play an important role in the decision-making process by examining committee. The victim would operate with greater rigor when it comes to the recruitment, such and such. Was highlighted again in the following state of Madhya Pradesh. It says it is clear that it cannot be required in such and such instances in respect of police service. Last persons were elected to either duty of the police or not to enter the police force. Considering the fitness and suitability of a candidate, 7.3 I am reading, the fitness and suitability of a candidate service to the employer. A host of consideration would legitimately find place in the process of such consideration by the employer to decide whether it is feasible or advisable to offer employment to an aspirant. From the employer screening committee of the employer has acted to discard the candidature by consideration has not acted arbitrarily or whimsically. The courts have no role to interpose. The institutional approach, employer would give the courts to exercise a power judiciary. So, Milad, says, but for the above limited consideration, only arbitrariness, whimsicalness, unreasonable, malafide approach, the scope of the judicial review is extremely limited. The courts are not expected to overlook the wisdom of the employer in judging suitability of the candidate, in considering the relevance of the antecedent candidate, and would not substitute its own view. That is my humble understanding. Then, Milad, evidence গুলো কোথায়? Evidence বুঝতে পারছি। Yes. Milad, I will take 5 to 10 minutes because permit me by Monday, I will serve a detailed notes of argument. If your lordship permits, by today is on Friday. By Monday, I shall give a.
These two submissions we will note right now.
Yes, but here, Milad, the question is, it is not by default. The credibility of evidence.
So broadly, you have made two submissions subject to what you may say. One is here in this case, the rules and judgment in the case of Boloram Bordoloi fortifies your submission that recording of reasons was not fatal, or non-recording of reasons was not fatal.
And I have given reasons by applying the word of the it starts from whereas and whereas, which indicates reason, recital of facts.
So therefore, he has relied on reasons which were recorded by the inquiry officer. Nothing new has been said. So therefore, it is not fatal.
But in case of disagreement, the situation would have
been. The situation is different.
Action taken on inquiry report.
Kunj Bihari Mishra comes into play, then everything has to be
when there is a concurrence, Milad, I am not further. If the reason may not suit him or according to his pleasure, but give reasons given.
Yes.
Number one, opportunity of cross-examination, all documents, adjournment, everything will have
things were not argued.
Are not argued. So these were there. Now the criminal code, in the criminal proceeding, Milad,
criminal proceeding, your submission is there is no automatic benefit.
No automatic.
So many things have to be seen.
So many have to be seen.
And one of the major things which have to be seen is what is the nature of acquittal recorded. Whether it is after considering the entire material on record, or it is for a failure on the part of the prosecution, or lack of evidence. In the latter two categories, there can be no question of automatically extending the benefit.
If there is I am extremely grateful, Milad. Milad, if there is only one single sentence, Milad, which says the prosecution failure attributable to the prosecution for not being able to, Milad, cross-examine the vital witness,
which, my lord, flaws attributable to the prosecution, and for which the honorable acquittal cannot be suited here, my lord, cannot be termed that is an honorable acquittal. At the moment it is not honorable acquittal, then, my lord, the question subject to judicial review, what my lord will say, that the discretion lies with the employer, that I will adjudge the fitness or suitability of an employer, which will not approved by the Honorable Supreme Court. It is not my whims and caprice. I said that gentleman had, but why this allegation
The
will come?
subjective satisfaction based on the
Based on this circumstances.
the nature of acquittal.
Yes. Now, my lord, with deepest respect to my learned senior esteemed friend, he said the same set of evidence. The number of witnesses, those who were examined, common witnesses, common set, my lord, 6 in criminal and civil, subject to what my learned senior friend will also say. Second, my lord, that the nature of evidence, it is not automatically. Suppose I say something there and say something here, because the questions were different. So the assessment of the evidence, if the Writ Court is invited to assess the evidence, first of all witnesses are not same. Only 6 evidences are same.
So one thing we want to know, after the acquittal was recorded, did they ask you to consider, and have you rejected such a claim?
My lord, today, my lord, my disciplinary proceeding concluded with punishment order, my lord, 2018, and the acquittal order came, my lord, 2021.
So again, we ask the same question. After the acquittal was recorded, did they approach you that in view of this acquittal, please consider, or they have directly raised this issue in the Writ Court?
Simply, my lord, they have gone for review, and they have not. Yes, they have gone for review. The review order
Based on the acquittal.
Yes, no. Just a minute, my lord, yes. Representation was made. Yes, 26, 2022, page. Just a minute. This is Miller, 26 August 2022, page Miller 326 and 331.
331 is your order on the representation?
No, it is the demand for justice.
No, we are asking you, did you consider?
No, Miller, no.
So there is no consideration by you?
No, because this is a demand. Before that, Miller, the review, there is no further scope for review. Because I became a functus officio. The moment, Miller, the power to review must come from a statute. Because the order of review, where is that review order?
So according to you,
Petitioner submitted a salutary appeal for revoking the order of review 28 March 2017. Then, Miller, appeal was not considered by us. 19th August. Then review petition, and review petition was dismissed on 11/11/2020. 11/11/2020 review, page 304. So, Miller, no review after this second review, Miller, is not permitted. So far as we are concerned.
No, but he approached you.
He approached us.
You did not pass any order.
No, I did not pass any order because, Miller,
I am just trying to ascertain the facts.
Yes. Now, Miller, with humility, I respond in to the best of my ability that my consideration after this entire journey, Miller, whether the law permits us to further consider. That is
understood. What you are saying is whatever jurisdiction I have exhausted.
Yes.
Therefore, even if there is a subsequent development, I will not consider.
I cannot take note of this unless the statute empowers me, Miller.
The statute doesn't contemplate of an action being taken by the employer in the event of acquittal.
Miller, no, Miller, there is no such, Miller, unless the review, Miller.
No, in some provision, in some statutes, we have seen that if there is an acquittal,
service rule.
Then
Your Lordship is right. Salute to Chirona, it was with you.
No, he will not give you also.
Yes. Millard, in this case, in this Calcutta Port Trust regulations, service regulations, our copy kahan?
अरे it is in a part of the paper book.
No, 95 to that. No,
अच्छा, it is a part.
The paper book.
Yes.
I'm told when it's a part in.
Which page, please?
No. ওটা বার করতে
It was a part of the compilation subject to correction, maybe.
I stand corrected. It's a part of the compilation. Yes. 207.
Just see if there is any provision.
Miller, subject to correction. I did not, Miller, find anything. I may have missed it. 7, 8. Daraja, just a minute. 8, Miller. Kindly take pen, Miller. কত? 8A is there, my lord, got it. 8 capital A. 8 capital A, page 10. Nah? Okay, oh, sorry, 8 capital A. Eight capital A আছে? হ্যাঁ?
এটা কোন সাল দেখাচ্ছ?
এটা দাঁড়া এটা না এটা না
এটা
এটা নয় এটা ভুল না এটা দেখাচ্ছি না এটা ভুল
দেখাচ্ছ?
না এটা দেখাচ্ছি না
It is action on the inquiry.
kindly comes to me lord special procedure in certain cases that is 11
Yes, that's what I am looking. That's what we are looking at.
special procedure
Right?
23 is a power of review
এসএসসি 18 আমার নম্বরে মোট 2টা মিলে
Yes, no specific provision.
so my lord this is 22 is a review now my lord হয়ে গেল
Sorry, my lord. Yes, my lord, this judgment is 2019, 20 SCC, 588, paragraph 14. 2019, volume 20 SCC, page my lord 588, paragraph 14 and 15. Mainly paragraph 14, 15, 15. May I have the notice of read for my lord's kind consideration. The fact that the fastest trial cannot operate ipso facto as a ground for vitiating misconduct which has been found in the course of disciplinary proceeding. The High Court of India is drawn an erroneous inference from the decision of M.P. Anthony, High Court and from the principle of law and judgment such and such. The principle of standpoint it judges to execution exception case based on the same set of facts and evidence in both proceedings is common without bringing up variance. And then we know it is undoubtedly incorrect that charge in criminal trial allows from the death of an such and such incident resulting from the firing bullet which took place from the weapon which was assigned to the first responding member of the force, but the charge of miscom is the ground of negligence in the first is handling his weapon and failure to comply with the departmental instructions in regard to the manner in which the weapon. Consequently, the acquittal in a criminal case was not a ground for setting aside the penalty which was imposed in disciplinary proceeding, having regard to the parameters governing the exercise of judicial review disciplinary. We are of the view that judgment of this is unsustainable. But the sentence in paragraph 13 Anthony is that the 6 number are common in criminal and civil. Here, Miller, the facts are quite different from this one, Miller, present in the case in hand. But in the case, Miller, where Miller, the কতগুলো সাক্ষী নিয়েছে এই দেখুন আর এখানে টোটাল নাম্বার অফ উইটনেসেস 11. Now, Miller, in this case,
there is a stark variance.
Stark variance. Here it is not a stark variance. But the question is, Miller, the question is here, Miller, that 6 common I said. In criminal proceeding, the number of witnesses, Miller, 11.
The statements are at variance.
Statements are at variance. So, Miller, it is an evidence. Oral evidence, documentary evidence are also.
Number of witness is not important.
No.
The quality of evidence.
Quality of evidence and whether when Miller the stand.
And the same evidence being judged on 2 different
parameters. So probability, preponderance of probability, it gives a wide amplitude. And Miller, I am not talking about suspicion. I said any man of ordinary prudence,
however high, will not take the place.
Today, the question is, Miller, first of all, Miller, many a times our perceptions, Miller, are frightfully narrow because we judge someone, Miller, by Miller looking appearance. But in this, Miller, an ordeal had to be faced by an employee, Miller, and who had to face, Miller, suppose criminal and Miller civil. It is not a case of no evidence. It is a question of that the quality of evidence had been adjudged by 2 different authorities. কোথায় গেল 2020 Now, Millard, only one thing that the without there being a variance. Question is, my lord, that there should not be any variance. Now, variance, my lord, starts its journey notionally, conceptually, that number of witnesses common in set because different questions, different answers, different authority, different parameters. Whether all are to be, my lord, adjudged, my lord, in this proceeding. I said this is not automatic. I say, my lord, with humility, and my lord, kindly have the charity to consider that the chief examination in the by one witness named, suppose Utpal Shah, in criminal case, the nature of questions that were put to him, and Miller, the nature of question put to the in the disciplinary proceeding, Miller, these two are also different. But at the same time, Miller, the since the parameters are entirely different, whether the court is prevented, Miller, from looking into and analyze the evidence, not as a court of appeal sitting over the judgment of the disciplinary authority, but if the court finds.
This was coming to our mind also. This was coming to our mind also. So that means in which case, how the court will understand without sitting in appeal whether everything is common or not.
Here it is not common, I said.
Then you say it has to be examined.
It has to be examined, and
So
without there being.
At the same time, you say we cannot be judicial.
No, I said, Miller, whether the court many a times has taken a consistent stand that we are not sitting as a court of appeal, sitting over the judgment. But yes, if there is an acquittal, then Miller, both the evidences are looked into. Yes, absolutely, absolutely. Otherwise, Miller, the justice will not be subserved. So I cannot say, my lord, as an authority, which is within the Constitution of India, I cannot, my lord, create any impediment that court should not look into. I said, my lord, whether court at this stage is justified in looking into from the conspectus of the fact. If the court prima facie convinced that the acquittal, whatever may be the one utterance is baseless, another is, my lord, want of cross-examination to the vital witnesses. If this sentence is there, if there are certain lacunas, my lord, attributable to, my lord, the prosecution also, then whether it leads to an inescapable conclusion that no, whatever may be there, it is honorable acquittal. He has not done something. And preponderance of probability and preponderance, it is cannot, these are the two words which cannot be reconciled in infinity, my lord, like parallel lines. Beyond reasonable doubt on the one hand and the other. How these two words can be reconciled, I don't know. Then, my lord, the court is always invited to look into this. Now, every discretion must be informed by reason. Whether, my lord, I say that on account of this, the Supreme Court said, my lord, in the last paragraph, paragraph 910, in that judgment, my lord, 2026, that suitability of a candidate, suitability when it is not that the allegation came and I asked him not to come. It is not like a professional appointment without any stigma. Your service is no longer is required. Namaste. This is not like that. Here, my lord, 11 witnesses have deposed. There is cross-examination. Everything was done. Even then, if the court feels that no, our conscience, it pricks our conscience, it beats our conscience, we must look into this because it is Article 21, a right to livelihood of a person. It's a question of a dignity of a person. I cannot say that Constitutional Court cannot. Question is whether it is right at this moment. It is for the court's wisdom to go into this. As an advocate, Miller, officer of the court, I can only place the facts and I cannot travel beyond the records. But, Miller, it is not, Miller, my mere likings. It is question, Miller, that Port Trust is a salutary authority. And, Miller, if a contractor makes this allegation against a person who was in authority and who could cause damage to a person and threat perception, because never, Miller, he said that this was not a case that he never asked for bribe. Payment was made, this particular color, this was the CBI, Miller, everything was there. But even then, the criminal court said there are want of evidence, and, my lord, sometimes it appeared to the court baseless. Now, my lord, why I tell your lordship?
Whatever was passed on review on 11/11/2020. On to page 304.
Yes. Annexure 31.
The date of acquittal.
Acquittal. Acquittal is 2021. একটু দেখি ডেট আমি কি ক্রিমিনাল কোর্টে জাজমেন্টটা বের কর
29/11/2003.
হ্যাঁ 21 29/11/2021 তাই তো 29/11/2021 তাই তো
After 1 year.
yes so Milad Milad I have Milad the subject to leave Milad I have Milad made a list of Milad the witnesses who deposed in the criminal court and in the disciplinary proceedings since
This
Milad
will be in support of your submission that the whole thing has to be seen.
if Miller the court wants to go into this after if the court satisfied that no this is not an honorable this is an honorable
You are making a distinction on the findings recorded in the trial which is based on this
yes
serious.
yes I said Miller it has no ramification or no bearing Miller so far as
We will record what we have submitted today.
Before they reply, you articulate this on a piece of paper and give it to them. They can make their submission with reference to that. We'll conclude on the next day. Because this issue they have not dealt with. They have not gone into the meticulous examination of witnesses in the trial in here. You are saying upon a threadbare consideration which is mandatory in terms of the Supreme Court order, there is a distinction. Stark variance, quality, quantity, everything is different. Perception also different. So they will.
may I stand I stand correct I said even if there is a variance the court cannot I said Miller same set of evidence number quality everything has to be adjudged
Exactly.
exactly
So there
there
is a stark variance according to you.
no I said variance Miller stark is a very harsh word for me only variance in paragraph
The variance is enough.
Variance is enough
because it says without there being any variance.
Any means
without there being a variance.
If A is article, so Miller a variance. Even if there is a single one, there is my and disciplinary authority has given a reasons and whereas recital. So Miller I am not required to.
So just give it to him. So Mr. Majumdar can make it.
Then 4 days time.
Take
I mean, kindly take it.
What has fallen from the bench?
Because see, now, whatever you have to submit, you have submitted.
I only restricted myself, confined myself to the submissions made.
Obviously, so whether there is a variance or not, you say based on this, there is a variance, they will say whatever they want, it is over.
But they would give by 5 and matter would be on 12.
Yes.
Should we write it 2 or 3 times already? Yes.
Deeply obliged, my lord.
Yes.
CPM.
3 p.m.
3 p.m.
Yes, concluded.
3 p.m.
Yes, yes.
Deeply obliged, my lord.
Item number 44 and 45.
And in 45, I am for the Margot.
Yes, first case you are appellant, second case you are respondent. You want to open with your submissions.
Before taking the brief, I like to place the gist of the case.
Please do
It may help me.
Please do so.
My lord, you also heard that the two honor the person to honor the persons who have sacrificed their youth or life for the freedom of our country. A scheme, namely Freedom Fighters Pension Scheme of 1972, was introduced on 15th of August 1972 to give them some honor by way of common pension. Lord, in that scheme,
You can't be the petitioner.
Yes.
You can't be the person claiming the pension.
I am the petitioner. I am one of the petitioners.
You are the person claiming the freedom fighter pension.
104 years of age. I am now 104 years.
Oh.
I am now 104 years. So what happened thereafter? After 72, in 72, there was the scheme. In that scheme, it was said with the application, the applicant is to furnish the official record
Official record.
of their sufferings. But those were not easily being available. As a result of that, the freedom fighters wrote to the government. In 1979, by radiogram message circulated to all the states, the state government was informed to form a state-wise advisory committee as well as a district-wise advisory committee who will assist or help the freedom fighters for collecting the official records. But in spite of the establishment of the district level committee and the state level committee, as the records were not available, then the scheme of 1972 was liberalized in the year 1980, renamed as Swatantrata Sainik Samman Pension Scheme of 1980. In that scheme, some relaxation was there, where there is no availability of records. There, the certificate of a renowned freedom fighter is to be given. After that, a question arose. There is so many freedom fighters in the district who have suffered some period. Whether everybody will be entitled to give the certificate or not, this question was raised. Then the government of India issued a circular in 1983. Sorry, in 1983.
80.
83. 1983.
So 79, 80, then 83.
Then in 83, it was prescribed that the state government will form a committee or form a list of the persons authorizing them to issue the certificate.
To certify participation.
Name of the list of the certifiers. who will be in a position to issue the certificate. Accordingly, every state prepare a list and send it to the government. Those certificates of those certificates would have been or is being honored by the government. This was the scheme. This was a scheme in a nutshell. On commencement of the act, I applied. The scheme. My client applied.
Commencement of the act, which act?
Scheme. Commencement of the scheme of 1980. Not act.
Under the 83.
Commencement of original scheme, that is 1972, renamed as in 80. Upon commencement of 80 scheme, my client applied.
When? What is the date of application?
I am giving. My client's application is, Lord, well, I'm just a minute. First application is, Lord, petitioners applied on, Lord, 14th of July, 1981.
14/7/81.
81. Your Lordship will find at page 67. But as per the scheme, applicant is to give the certificate from the government that there is no availability of records. That is, record is not being available. If record be not available, then the certificate from the certifier comes into play.
So his first application was under the 1980 scheme.
80 scheme.
Where is the 1980 scheme?
1980 scheme, your Lordship will find at page, I have annexed that. In that the scheme which I referred just now, my Lord, your Lordship will, prior to the your Lordship can take pain to 80 scheme, 72 scheme, because your Lordship have a look to page 50 for a moment.
1972 scheme.
Scheme, page 50, volume 1. Volume 1, page 50. This is the original scheme. Shall I read the preambles of the scheme? The Freedom Fighters Pension Scheme commenced from 15th August 1972. The scheme provides for the grant of pension to living freedom fighters, their families, if they are no more alive, and to the families of martyrs. The minimum pension sanctioned to a freedom fighter be ₹200 per month. And in the case of the families, it will vary from ₹100 to ₹200 per month. Not more than one member of the family can be granted pension under the scheme. Those are not so much, who is the eligible? In page 2, paragraph 3, subclause 2, a person who remained underground for more than 6 months, provided he was a proclaimed offender.
So yes, we have seen.
Say,
yes.
My Lord, I like to
jail for 6 months, internment or externment for 6 months.
I will show another one.
Confiscation of property and all these things are there.
Your Lordship, then straightway come to paragraph 12. Well, I like to show the paragraph 12, page 53. Duration. How long the pension will be paid? Except in the case of unmarried daughters, the pension is for the lifetime of the recipient. In the case of unmarried daughter, pension ceases immediately after they are married or become gainful, but are established. So then your Lordship kindly come to Roman 2 of that duration, Roman 2. the minimum pension, the pension, Roman 1, sorry, Roman 1.
Note 2.
Roman 1, Note 1.
Okay.
Roman 1.
Yes.
The pension scheme commenced from 15th August 1972. Applications received on or before 14th August 1973 will be sanctioned pension from August 15, 1972. I'm pressing here. Then application received thereafter, that is after August 73, will be considered for pension only from the date of the application. I'm just here, I like to stay here. That is as per the scheme, if it is done before 73, August 73, he will be awarded pension from 15th August 72. If he apply thereafter, he will be awarded pension from the date of his application. Then you will also come to the next scheme, that is which was liberalized.
1980 scheme.
80 scheme. Your Lordship will find it starts at page 54. I should place the preambles first.
This is of 81.
It is, though it is 81.
Notified in 81. Notified in 81.
Yes. But scheme is 80.
80, yes.
Yes. During 25th anniversary of independence, a central scheme for the grant of pension to freedom fighters and their families from central revenue was introduced by the government of India. The scheme commenced from 15th August 1972 and provided for grant of pension to living freedom fighters and their families if they are no more alive, and to the families of martyrs. The minimum quantum of pension sanctioned to a freedom fighter by rupees 200 per month, and in case of families varied from rupees 100 to 200 in accordance to the size and number of the eligible dependent of the family.
So no ceiling. After this, no ceiling.
No ceiling. Ceiling was
abolished.
Ceiling of 5,000 per year.
Whatever it was
abolished. Now, Lord, your Lordship knows the law scheme. I need not travel, my Lord. Your Lordship, I will take my Lord straightway to paragraph 9B at page 58.
D.
58. Documents.
You are referring to B, or you are referring?
Better, your Lordship, kindly excuse me to come 57 for a moment to see the head note of para 9.
How to prove the claim?
Prove?
Yes.
The claim evidence. I am claiming underground, so I am taking my Lord to the next page at 58, paragraph 9B. Remain underground. It is my case. I remain underground. But the paragraph Roman I of B says, first of all, documentary evidence by way of course, government orders, proclaiming the applicant as an offender, announcing an award of his head or for his arrest, or ordering his detention. These are the documents to be furnished. In case, if those documents are not available, what documents will be required? That has been prescribed in Roman 2. Roman 2. That page. Certificate.
Yes, yes.
From veteran freedom fighters who had themselves undergone imprisonment for 5 years or more, if the official records are not forthcoming due to their non-availability. That is, if the records, as I understand, if the records are not available, then my lord, applicant is to apply, can apply the application with the personal.
Correct. Now we have understood.
But in that event,
So only your case is that once the ceiling was removed, you became eligible, and therefore under 9B2, you are to make your application with a certificate. Now, what?
your lordship will not see the alternative evidence or the secondary, as my learned friend are always saying it is a secondary evidence, secondary evidence.
No, he has not argued yet.
No, they have raised earlier. So now they are saying secondary evidence. Nowhere it is secondary.
See, primary,
Yeah, I understand, my lord, your lordship has come to the scheme.
No, I have done some cases, so I know from beforehand.
I am sorry, my lord, I am sorry.
But no, we are just trying to understand. We have seen what you want to show. We will see what you want to show.
Yes.
But your case, which appears up to now, is that the ceiling was coming. When the ceiling was removed, you applied for an application. We rely on the 80 scheme. 80 scheme provides that a certificate can be given by another certified, by a person competent to certify.
Yes. Perfectly right.
Yes.
My lord, I applied in 81.
Yes.
But my application is at page 67. But along with
page 67,
volume 1, page 67, my lord. This is my lord, it will be better to look into 71 because it is type copy.
Type copy. Yes.
It will be legible for me. This is my application. And prior to that, if your lordship kindly come to page, my lord, 66, your lordship will find a certificate issued by the district magistrate of Midnapur, undivided Midnapur. Now East and West Midnapur. Previously it was the only one Midnapur. But this was issued by the government, and on the basis of that certificate, I applied. But sorry, I should read the certificate. This is to certify on the basis of the report received from the officers in charge of the concerned police station that no relevant records relating to issue of warrants, proclamations, and prosecution during the period 1930 to 1946 are available. So, in terms of Roman 2, I am coming to apply on the basis of the PKC at page 76. Oh, can you document? So my learned junior is indicating to disclose before my lord as to why the records are not being available. But
that is immaterial. The scheme provides, if not available, to rely on certificate. There is a certificate of the district in charge saying there is no record. So why it is not available is, even if it is for invalid reason, that will not discredit your claim.
The fact is otherwise here, after getting the freedom movement, when the Tamrolipta Jatiya Sarkar has established a peace government, national government, for 18 days, having its military, judiciary, and force, they all burned the police record.
That is not relevant. That is not
in the record history books. I can provide that.
That is not relevant.
That is not relevant. Now, my lord, your lordship will see the 76th page, the PKC, the personal knowledge certificate of my certifier, Sushil Kumar Dhara. My lord, here I like to introduce Sushil Kumar Dhara. I should say something about him. Like he was an MLA, MP, and minister of the state, as well as he was the commander in charge of two military wings of the Free National Government. One is Bhogni Nivedita Sena, led by Matangini Hazara. Another is Vidyut Bahini, led by R.N. Giri and others. He is the Sushil Kumar Dhara. Your Lordship kindly peruse the qualification, his sufferings at page 76. He has certified that he has suffered imprisonment for 5 years and 7 months. My lord can see the page 78. It is a typed copy.
25 months. He has certified for 25 months.
No, my sufferings. My suffering is 25 months.
Correct. He has certified
his
for
suffering. Why I am showing, Lord, his suffering 5 years.
5 years.
7 months.
Yes, 5 years, 7 months.
My lord, then your lordship kindly come to page, my lord, 80. And your lordship will find that state government sought for his confirmation as to why he has actually issued the certificate in favor of my client or not. Then your lordship can see the reply of my certifier at page 82. Sorry, my lord, 83, my lord, it is 83. Reply of my certifier. He has replied, I have certified, but inadvertently, he was, in his certificate, he was mentioned that he was a proclaimed offender instead of the person on whose detention order were issued. So he corrected. Accordingly, my client also corrected by his application.
What was corrected?
82 your lordship can have a look.
83.
83 is certifier's correction. It is 22nd August 1983. And I also corrected as per 82.
So instead of and, he has said as he was a proclaimed offender. Yes.
So then your lordship kindly go back to page 84. Rejection. My lord, serial number 3. Tick mark. The cyclostyle copy. Mark. Certificate of absconsion submitted is not acceptable since Sri Dhara's sufferings from actual imprisonment is less than 5 years. Well, I don't know how they have come, not more than less than 5 years, but certificate itself shows 5 years and 7 months, as your lordship also found. That is
no, they are saying about your certifier.
Certifiers, yes. As per the scheme, it was required 5 years sufferings. It was subsequently reduced to 2 years. Well, had your lordship prevented not to put that, and your lordship, well, conversion with the same, I did not test that scheme. Initially, it was 5 years, then reduced to 2 years, and in spite of the same, my certificate, though was 5 years, 7 months, suffering, certified, and that certificate has not accepted because he is not suffering is not more than 5 years or 5 years. So according to me,
So how they will know that he was incarcerated for?
In that event, all these applications
Less than 5 years.
are.
Where is the letter which changed it from 5 to 2 years?
Yes, my lord. My lord, your lordship kindly come to page at 64. 64. Lord, your lordship kindly take pen to come page 65. Page 65. My lord, I should show the date 21st of August 1984 at page 64. I am showing the relaxation of the sufferings of the certifier at page 65, paragraph Roman 2(3) of paragraph 2. The above relaxation, that is reduction of certifier's jail sufferings from 5 years to 2 years, will be applicable to claims already received before 31st March 1982.
No, this relaxation is.
So it is not necessary to us because our certifier was suffering was more than 5 years. It was not needed to us because certifier suffering, your lordship has found 5 years, 7 months. As per the original scheme, 5 years real suffering is required.
This qualification, which is altered by this letter of 21/8/1984, this alters the requisite period of incarceration for a beneficiary, not for the certifier.
That has not been reduced. That is minimum 6 months. If it is less than 6 years, he will not get. If a person at least suffered 6 months,
Certified, issued by a certifier who had undergone a minimum imprisonment of 2 years instead of 5 years.
Will be eligible to certify. Even if they certified earlier, 2 years, that will be accepted now. This is the scheme that is the notification of 84. Malad, as your lordship is taking page number 65, will your lordship only come to page paragraph C of that page?
That is what we are reading. That is what I am reading.
Yes. The state government, etc., are requested to indicate invariably the document certificate on the basis of which they accept the claim of a certifier that he had suffered imprisonment for a minimum period of 2 years. This will facilitate the expenditure clearance of the claim recommended by them.
So he is getting pension. Your certifier?
Certifier was getting, he was a renowned freedom fighter. He became the minister and he was, what not. He has died in 2013. In the district of Midnapur, there is a memory in his name.
So what is the
Saudha also in his name? Well, I am fortunate enough. I have come from that district. There are so many persons of our family included in the freedom struggle.
Yes.
And anyhow, my lord, another thing what I mean to show your lordship, As your lordship seems, I said that the government was requested to prepare a list of persons who will certify. That has been prescribed in 86 scheme paragraph 2 at page 62. Accordingly, they did, and Sushil Dhara and four, 5 others were impaneled, and their names were forwarded to the government of India. It is admitted that. Then, my lord, your lordship has found the rejection, first rejection of the state government at page 82.
84.
84, my lord. Against that rejection, my client made representation. And after that representation, second rejection by the state came, Lord, in 86, which will be evident at page 86.
86.
86. I like to read last 4 lines. The case was therefore examined again on the basis of the certificate from Sri Dhara, and the State Advisory Committee was consulted. The certificate of Sri Dhara could not be accepted, and Sri Dhara, having one certified absconsion on one ground, subsequently changed its showing that he had no, subsequently changed, it shows showing that he had no personal knowledge. Exactly. On that ground, they rejected.
Because of that correction.
Yes. They said, as you took the first time, the proclaimed offender, and subsequently you are saying that you are a person on whose, for whom head was declared, but you apprehended arrest. So you did not have your exact knowledge, so your certificate would not be accepted. This was the ground of rejection at page 86. Then, my lord, against that, my lord, so many matter gone, and ultimately rejection, then the representation the government was given.
No. So they have to, only thing they have to show to justify the rejection, that such discretion was vested in any authority to examine the correctness of the certificate, whether it could be examined or not. Once it certifies, under the rule you are saying, once it certifies, certificate is by a competent authority, there is no scope for looking into these things.
Yes. But whether that is so much vital or not, I will come.
No, first thing is,
it has been decided.
Can it be looked into? First thing is, can it be looked into?
Yes, it has been decided. This point was taken by the Union of India as well as the state before this honorable court, before the division bench.
So what is the decision?
By the single bench, it has been decided. This is nothing, no harm, no change. Because same thing, proclamation was issued, not arrested. Head was declared, not arrested, evaded arrest. Matter is same. So there is no change, nothing of the sort. On that score, you cannot turn down the claim. That is the division bench judgment of our court. And they have accepted. They have complied with the division bench order.
Very well.
So that is
where is the judgment?
The judgment below. Then again, I am coming below that judgment. It has been discussed even in the impugn order. In the case of the Lichuwala Ghora, it has been. Lichuwala Ghora, but in the case below, just a second, I am giving on the point of pension. I will give. Correction. Judgment এটা দাও লিচুবালা ঘর দেখো সি জাজমেন্টটা লিখে না বলে দিচ্ছি লিচুবালা ঘর একটু দিলেন না 2017 5 CHN